law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been designed to educate, inform, and help you understand the law better, because it does matter to you. Understand the law better, and you're in a better position to protect yourself, your family, and your business. We'll be presenting information and resources that might help you decide whether or not you might want to handle some issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and so will they. Of course, the goal is that you will save time, save money, and hopefully achieve the best possible results. We once again want to begin by thanking the Bazar law firm in East Providence, who continues to provide their insights and resources on all of the topics that we tackle. And we want to welcome David Bazar, Attorney David Bazar. And today we have with us also a special guest, Attorney Larry Barron.
Hi, Deb.
A little bit of background here. Larry Barron from East Providence also has represented Rhode Island and Massachusetts residents for 30 years. The firm counsels individuals, families, same-sex couples, business owners in estate special needs, asset protection, business succession, retirement, tax, and charitable planning. So we're happy to have you with us.
Good to be here.
As a result of that, so today we're going to be talking about financial planning, tax planning, trusts, irrevocable trusts. We have talked about living wills and various estate planning issues over the past few sessions, so this is a good time for us to have someone who has some specific information to share, especially as it sometimes means that David and Larry may work together. So it's interesting, people always want to hang on to their money, their assets. They don't know always how to best protect them, how to pass them along, what to do with them, how to do it safely. There's rules, there's regs, and it's always in flux. So if someone, say, begins with you, let's start with you, David. If someone begins with you and wants to do some estate planning, how might this initially set up, and at what point, and how does it segue to include Mr. Barron?
Okay, so when somebody comes in, we'll talk a little bit, as Larry has trained me, about the two things that go into an estate plan, people and property. And when we go through it, if it's a fairly straightforward will-centered plan, I might be able to do that on my own. But when we get to a more complex situation where they want to use trust and irrevocable trust for life insurance and other types of situations like that, then I'll walk them across the hall and say, hey, Larry, these are some folks you'd like to meet and talk to, and then we'll go from there.
So there are various instruments, Larry. Help us set up what some of those are, who needs them and when.
Sure. You know, when most people come in to talk about estate planning, they come in thinking that it's all about death planning, what happens when we die. And what I typically tell clients is that death is the easy one. The more complicated situation is if you are still here, but you are not able to participate anymore. So we spend a fair amount of time, and it's my job to make the clients aware of the need to put some planning in place in case they suffer mental incapacity, either a stroke or they just start to decline slowly as they age. And one of the best ways to protect assets from the red tape that is associated with probate is through the use of a living trust, a revocable living trust.
A revocable.
Revocable.
Because we need to touch on also what the other side of that, or the irrevocable, is.
Sure.
Explain what a revocable trust is.
A revocable trust is the primary advantage that you get out of having a revocable trust is being able to avoid the red tape that's associated with probate, either at death or in the earlier event of mental incapacity. And so if you arrange your affairs by creating a revocable living trust, and more to the point, you then put your assets into that trust, whatever assets are in the trust will avoid having to pass through the probate process. And probate is a very public process. It's fraught with delay. It's expensive. There's the oversight of the probate court, which, if you have a family that works well together, is not really necessary. So we use the revocable trust as the primary planning vehicle for folks who are either trying to arrange their affairs for death or, as I say, in the earlier event of a mental incapacity. And the nice thing about a revocable trust is that it's revocable, so that if there's a change in circumstances, if the assets change, if the family dynamics changes, the clients can always come back in and tweak it, adjust it to meet the changes.
So David, if someone comes to you and starts to talk about wanting to plan for the next generation or what happens in the next stages of their life, at what point do you know that someone needs to have a revocable trust? Is there a certain income? Is there a certain amount of property? Is there a certain amount of wealth that they need to amass? Or is it just a matter of perhaps what might be a complex family situation? How do you pass it off to David? How do you determine that?
All of those things
Okay.
actually could apply. There's certainly some monetary issues and what type of assets you're holding.
Such as?
Well, money versus real estate can make somewhat of a difference in whether it needs to be a revocable trust or not, because you can at least pass real estate through to the other generation in some other different forms, such as life estate deeds, if that's appropriate, or other types of things like that. We talked and we've done before family or real estate LLCs that might be able to do the same thing with real estate, limited liability corporations. Versus a trust.
Okay.
Perhaps.
Okay.
It depends on what the assets are and what the situation is and what it is you're trying to accomplish. So you look at the type of assets and the amount of assets, because if you're really dealing with limited assets, it's a little bit more expensive to use the trust-centered planning, so you might not want to do that. And then, of course, who the people are and what the needs of the people are and what you're trying to do to protect your assets, as Larry says, through a disability or through death. And so with a disability, if there aren't a lot of assets to deal with, but there are some other family issues, you might use a power of attorney, which can serve instead of a guardianship in that instance. And of course, all of these plans require healthcare powers of attorney to help make healthcare decisions.
And David had just started to mention revocable versus an LLC. Who needs that? How do you make that decision?
LLCs typically are for business assets.
Mm-hmm.
So if you buy real estate that you're going to use as rental property to generate rents, income for yourself, to protect your other assets from any bad stuff that may happen at the property, slip and fall, fire, you would want to have that real estate owned by an LLC. One thing I wanted to say too, though, I think it's important to, talking about death is not what people like to do. And so we all know people who say, yeah, I'm going to get around to talking about this at some point, but they procrastinate. What I think it's important to know is that, people don't like spending time with lawyers for the most part. So, we're asking people to confront your mortality and, oh, by the way, meet with a lawyer to talk about this. So one of the things that David is great with is getting people comfortable to talk about the thing that makes these plans either work or not work, which is the family dynamics. And again, so I think people should know that there are certainly lawyers out there who will approach this with the sensitivity that's really necessary to help the family do this planning, because at the end of the day, what the plan is it's an act of love. It's a commitment to your family not to leave a mess behind, but to get everything in place so that when something crazy happens, when someone passes, mom and dad or the survivor can say, you know what, we did the grown-up thing, we got our affairs in order, and here it is. So.
And if you're dealing with families, David, where there are second or third marriages, several sets of children, grandchildren, does that direct you to begin that counseling of sorts to prepare them for what will be the next generation of passed on assets?
There's a lot of that goes into that, and yes, the short answer is yes, but Larry and I have both seen the consequences of failing to plan, and families that can get ripped apart by not planning, and actually been involved in situations where people have gone to attorneys early on and have made some plans and now want to undo them. And we talked a little bit about life estate deeds, and a lot of times people too early in their life add children to life estate deeds so that they want to change them. The children have to sign them. And I had a case once where there were 8 children on a deed, and the father died, the mom wanted to change the deed. She wanted to put it into an LLC, actually, and name one of the children as the manager of it, just so that it would be easy to manage after her death. And two of the children refused to sign the deed to put it into LLC, so it blocked her from being able to do what she wanted to do. And I'm sure on her death it's going to become an issue. If they wouldn't do it while she's alive, I can only imagine how this is going to be an issue on her death.
Larry or David, could you just back up for a moment and explain what that instrument called a life estate is and how it's used, what its planning function is?
Sure. There are a number of ways that two people can own something. You and I can own that clipboard, and if we own it together, now, jointly, if I want to use it on Tuesday, I got to get your permission. If you want to use it on Friday, you got to get my permission. Another way that we could own that is you could have what's called a life estate, meaning that you get to use it to my exclusion. If I want to use it, too bad. You get to use it whenever you want, and as long as you're alive, only you can use it, and you can keep people away. And when you die, it's mine. So, in fact, whether I survived you or not, so and what I have is called a remainder interest. You have the life estate. So with real estate, you can picture how, a mom might give the remainder interest to her 3 children, but keep for herself the life estate. And with real estate, the nice part about it is that no matter what trouble her kids get themselves into, mom can never lose the house because her right to possess it, to live there, is exclusive. So again, as long as she's here, she gets to use it, enjoy it, have wild parties, whatever she wants. Can't burn it down, but pretty much everything else.
And so to your point, David, is if it was done too early, and is it that the situation with children may change?
Well, too early, too many children in that particular instance, with too many personalities and too many interests, so that to change it, it requires everybody who has any interest in the property. If she wanted to move to Florida and sell the property, they would all have to sign the deed to allow her to do that. And so that needs to be counseled to anybody who's thinking about signing one of those deeds, is what are some of the consequences.
So if she can't get consensus, what happens, David?
Well, she can file a petition for partition in Superior Court.
Separating herself from this?
Well, dividing the interest in the real estate up and having a commissioner appointed to sell it, and there's a value that's given to the remainder interest, and if they're not going to give that back to mom, they're going to get their remainder interest now. And if there's a lot more assets, then that might be made up some other way.
Right.
Now, if we're not specifically talking about Medicaid planning, but is not a life estate also used in Medicaid planning in some cases, so that someone can stay in the house while the other one is in a nursing facility or something?
Yes and no.
Okay.
Medicaid, the rules for Medicaid are complicated.
Yes.
There was this technique called a ladybird deed, named after Lady Bird Johnson, and I don't really remember why, but the concept was that you could set this whole thing up, and then as the mom, say the parent, and then with the life estate, and then if you change your mind about it because your kids aren't playing well, you take it back, undo it without their permission, without their consent. And this technique was very effective in the Medicaid context. In Rhode Island, this technique was basically shut down last July, so we don't see a lot of life estates, at least for Medicaid purposes, anymore.
Good to know.
Yeah.
When you began talking about the revocable trust, when people are drawing those up and you counsel them, I imagine that you need to ask many questions about what they have, what they do, who they want it to go to. Is the revocable trust the primary instrument that people use when they want to make sure that no one else gets to know what is in their asset list? Exactly right.
One of the hallmarks of probate is that the executor has to file an inventory of all the assets, pretty much down to the toothbrush, and that's a public record. So with revocable planning, none of that sees the light of day. It's all private.
Is that true even if it were to be challenged? If someone who is involved with it says, I want to take issue with that, is that something that is concrete and can never be disrupted or challenged at all?
Well, this is America, so anybody can challenge anything.
Yes.
But it's more difficult, more expensive to challenge a trust than it would be to challenge a will. I mean, the place where we approve wills is the probate court. So you're in a court, which is, we have our fights in courts in this country. The revocable trust, administering the revocable trust, takes place not in a court, but again privately. So to challenge that, you would have to file a lawsuit in Superior Court, much more expensive, much more difficult to pursue.
And at what point does this instrument called an irrevocable trust come into play, and what is that? If you'd explain.
Irrevocable trusts, for people who are living and want to set up an irrevocable trust, there are some Medicaid techniques that would employ this, but typically the irrevocable trust would be used for people who have money that they don't need anymore, that they are happy to say goodbye to it, because once you put it into an irrevocable trust, it is irrevocable. You can't get it back. If you're looking to get a tax advantage out of it so that it's not counted as part of your estate when you die, it really has to be hands-off.
So, Larry, is that the primary reason someone might consider having an irrevocable trust versus a revocable trust?
Yes, exactly. So someone who sets up an irrevocable trust while they are alive, it would be because they're looking to save on estate taxes, and the people that they want to get this money, to enjoy it, are not capable of handling it all at once. The other place where we use irrevocable trust is within the revocable trust. So the revocable trust acts as a will substitute. The revocable trust says, when I die, here's where I want my stuff to go. What we typically recommend for our clients, and our clients are very much on board with it, is the inheritance that we leave for the children, we put those into irrevocable trusts. So that the money is available for their enjoyment, but not available for them to lose either to a bad marriage, children who text and drive, or just bad luck.
Let me ask you one question about that specifically. If it's an irrevocable trust, and you question whether or not it would be a problem inside of a divorce or whatever, isn't that a non-marital asset if it's a family that passes something along to their child? It's not part of the marriage, it's part of what you gave to your child. Isn't that...
It depends what state you're in.
Right.
Oh, okay. Good.
Yeah.
Okay.
In Rhode Island, you're correct. In Massachusetts, not so much.
Okay.
Right. So, and the nature of the game in protecting assets is to put up as many obstacles as possible. So if I live in Massachusetts, where inheritances typically are considered a marital asset, and I leave this inheritance to my child, but in an irrevocable trust, my child has a pretty strong argument to say, you know, that really isn't mine to lose in this divorce. My parents set it up in an irrevocable trust, and yes, I get to enjoy it, but it's not mine to lose. And that argument would probably carry the day.
Explain that there should be some tax advantages that are supposed to be legal. That's why you can do it. Mm-hmm. What are they, without getting into the weeds, without getting too nitty-gritty with? Who benefits? You said the person who's making the trust benefits. Who else and how? Who else benefits?
In terms of creating an irrevocable trust,
yes,
for someone who's living now?
Yes, and then the child who inherits, do they have some benefit if, say, stock goes into it, or an appreciable asset, et cetera? Okay.
So if I have lots of money and I put some of it into an irrevocable trust, that money is not going to be counted as part of my estate for estate tax purposes, at least on the state side. On the federal side, I would need to account for the fact that I made a big gift back in 2015. But certainly any growth that happens in that asset, so if I put stock in Google when Google is 2 years old into this irrevocable trust, and many years later when I pass, it's now worth hundreds of times what it was when I put it in, all of that growth takes place outside of my estate. So that's one technique. The situation I discussed earlier about a parent leaving an inheritance for a child in an irrevocable trust, the nice thing about that additionally, in addition to it being protected from bad marriages, is that what's in that trust when that child dies is not counted as part of that child's estate for estate tax purposes if it's properly structured.
So I've had a client who had a fairly good-sized corporation, closely held, which means owned by the family, owned by the client, and they created an irrevocable trust in 2 classes of stock, which all had the same value capital-wise, but 1 share of voting stock and 99 shares of non-voting stock. So they put the 99 shares of non-voting stock in over time through gift. I think there's a crummy technique where they could put it in and give the people who would be the beneficiaries the right to withdraw it, but of course they would never do that. And over time put all the stock of the corporation into the irrevocable trust, so it's out of their estate, and proper federal tax gift returns would have been filed when and if necessary. And at the same time kept control over the running of the corporation because they kept the 1 share of voting stock, which is the stock that controls how the corporation is run. So they were able to take out many, many dollars from their estate, stock that is really of no value until the business is sold, but of very big value if they died and had to go through estate tax on it. Sure. So save both estate tax, get it to the next generation, and I believe with the generation skipping possibility, so that, as you said, the children who inherit it leave it in, they can go to the next generation without impacting their estate tax.
When you're talking about these estates, whether it's in a trust that's revocable and irrevocable, are we needing someone to be worth $1 million, $2 million, $4 million, and more? Is there a bottom line cutoff past which it doesn't make sense for them to go through the energy, the effort, the expense of having a lawyer, et cetera?
Sure. Again, if we're talking about passing inheritances to children, what drives that conversation is, I'll say, are you interested in a way that you can get an inheritance to your children that's protected from bad marriages? And gee whiz,
you would say that to someone?
Oh yeah, and almost 100%, the parents are always concerned about their children's marriages. I mean, the divorce rate in this country is over 50%. So it's a real concern.
Which of those instruments does one need if the parent wants their child to benefit from that asset, and perhaps even for the child and his spouse, but for that spouse to never actually have that asset? What takes care of that? How does someone deal with that?
Yep, good question. So generally speaking, trusts are powerful. So typically you think of a trust as being money locked away in a bank vault somewhere. That's not what it has to be. Trusts can hold any type of asset. So we could have $1 million in a trust, and the trust could decide, let's go buy that property that's on the water and have the trust own the property on the water. And the client's daughter, this is after the client passes, the client's daughter gets to use the house on the water. She can ask her husband to come spend nights there as well, if she likes. But if the marriage goes south, the daughter has a pretty strong argument to say to the family court judge, yes, I let him sleep here on occasion, but it's not mine to lose. And so here the inheriting child gets to enjoy it, gets to share it even with a spouse. But if things get hot in that marriage, she has some deniability.
And what if she dies?
If she dies, typically the trust would say that it goes blood to blood, so it would go down to her children. We typically, again, since most of my clients tell me they don't want to rule from the grave, we can give the child to say what happens to what's left in the trust. So if the child wants to, in fact, leave it to a spouse because it's a wonderful marriage, well, why not?
Is that a power of appointment?
It's called a power of appointment, yeah.
So when you start to work with someone in some capacity, David, you may or may not know whether or not they have a will or an estate to begin with, but I'm sure you'd get around to asking that. At some point, do you have to then ask them, can you please make a laundry list of everything that you own so that I can know whether or not we need to do some irrevocable tax planning, bring in Larry, bring in financial people? Do you ask for that in the course of your relationship with your clients, or vice versa?
You have to, because if you don't, then you're not necessarily being able to perform the proper job for the client. In fact, if I've had the interview, I've met with them, and I've got to the point where I know that there are assets that need to be protected or dealt with, and I refer them to Larry. He's got a form that he would send with personal information form, which they would fill out so that they don't forget what they have too, because a lot of times when I'm meeting with someone, I say, well, let's talk about what the assets are, what's the property. They'll start talking, oh yeah, and I have this too, and I have that too. So they sometimes don't remember. So Larry's form gives them a chance to sit down and really think about what it is that they have and where it is.
And might either or both of you at times also need to bring in a financial person beyond the combined skills that, say, you two have?
Sure. I mean, the skills that we have are to how to get assets to the right people in the right way, but the clients are going to have questions about how do we get the most out of our assets, how do our assets grow, and that's not our expertise. So absolutely.
So what comes to mind, well, you mentioned the Apple or Google stock, for example, you might have guessed quickly that if someone bought it many years ago that it's worth much more now. But if you aren't yourselves involved in investments, you might not know what that entire list of stocks were worth and what happens when they go on to the next generation. And if you're going to plan for that, taxes or otherwise, you might want to bring in someone else.
And you want to have a financial planner, manager person to manage the wealth for them or help them, because that sometimes is important for the next generation too, and having that person introduced to the next generation early on can be helpful.
Sure, sure.
What's the most challenging kind of trust setup that you've worked with? What makes it most challenging?
The people.
The people, not the assets, not the stuff.
It's the families and the family dynamics. And I don't know if there's a direct correlation between wealth and family dysfunction, but it's
pretty close.
And you need to take that. You need to be cognizant of that when you're working with the family. And so one of the things that David and I both do, when we sit down with the clients, in addition to getting this long list of the assets, is asking them to come clean with the family and who's going to behave and who maybe not, and who we can count on and who not. So that's all part of it. And so what really drives these plans, what makes them work or not, are the people.
My favorite Larry line is, early on in his career, he would say, there are two P's that go into a plan, the people and the property. And the property is not going to cause the problem, the people are. So let's talk about the people first.
Sounds right. I guess that can also be a changing issue, too. Sometimes they're nice, sometimes they become not so nice.
Right.
We hope that this has been helpful to you. We hope you have a greater sense of awareness, and if you should need outside counsel, hopefully you'll know what to think about before you go to see them. Larry, David, thank you so much for tuning in.
Thank you.
Deb,
hope you'll stay tuned and stay with us, because the law matters, and it certainly does matter to you. Thank you for watching.